Good morning, this is your Kelso Report for Wednesday, November 16th, and I'm your host, Clark Kelso. Well, the news of the day, we focus today on the efforts of the Occupy Wall Street movement to maintain the locus of its protest activity in city parks around the country. During the first few months of the movement, city officials largely tolerated the primarily peaceful protests. The attitude of local officials began to change when they realized that the movement was setting up permanent tent housing that inevitably brought with it serious problems involving cleanliness, public health, garbage cleanup, and public safety. One by one, cities around the country have begun to reassert their police power to limit use of public parks to certain types of activities at certain times of the day. In Sacramento, for example, lawyers for the protesters filed an action in federal court preemptively to attempt to block any effort to enforce the local use ordinances against the protesters. In other cities, officials were forced to take the initiative by announcing that protesters would be removed from the parks forcibly, if necessary, and resistors would be arrested. In these cities, which include, of course, Oakland, and as of yesterday, New York, the protesters waited until police began eviction efforts and arresting protesters before raising their legal arguments in court. Well, in all of these cases, the protesters try to assert that they have First Amendment rights of speech and assembly that were being violated by the city's efforts to enforce local ordinances restricting the times and uses of city parks. So far, the courts have unanimously ruled against the protesters. The basic law here is very well settled. Cities can enforce reasonable time, place, and manner restrictions upon large public gatherings, so long as those restrictions are content neutral and applied in a non-discriminatory manner. The New York case yesterday was particularly interesting because the park in New York City was actually a privately owned public access plaza that was created by a city planning special permit issued to a building developer about 50 years ago, in exchange for bonus development rights that were given to the owners of adjoining properties. Now in this case, the owners actually adopted rules forbidding 24-hour camping in the park only after the protest had begun. The New York Supreme Court treated the privately owned park as though it were publicly owned and subject to the First Amendment. It then upheld the rules as reasonable time, place, and manner restrictions. As the court explained, quote, "To the extent that city law prohibits the erection of structures, the use of gas or other combustible materials, and the accumulation of garbage and human waste in public places, enforcement of the law and the owner's rules appears reasonable to permit the owner to maintain its space in a hygienic, safe, and lawful condition, and to prevent it from being liable by the city or others for violations of law or in tort. It also permits public access by those who live and work in the area who are the intended beneficiaries of this zoning bonus," close quote. The leaders of the Occupy Wall Street movement must surely understand that they are likely to lose these sort of legal proceedings, which is why I expect we will see the movement slowly move away from 24-hour occupancy of these spaces to other locations, such as college campuses and universities, where officials may be, at least initially, more tolerant of semi-permanent protests. But even at universities, guests can overstay their welcome, which is essentially what has happened to Occupy Wall Street and the city parks. And the First Amendment does not give protesters a right of a permanent occupancy on someone else's or even the public's property. We have 3 one-liners for today. First, in the area of malpractice, in Kodayari versus Mashburn, the 2nd District affirmed the dismissal of a malpractice action filed against Criminal Defense Counsel, which alleged that the counsel's deficient representation caused the plaintiff to be found in violation of probation, which resulted in the plaintiff being incarcerated longer than was necessary. The plaintiff sought damages for emotional distress and lost income resulting from his incarceration. The 2nd District held that the actual innocence rule applied, which requires that the plaintiff demonstrate actual innocence of the probation violation, allegedly resulting from the defendant's malpractice, and also actually obtain post-violation exoneration of the probation violations. Because the plaintiff did not comply with these requirements, the Superior Court granted the defendant's demurrer. Now, the actual innocence rule derives from the California Supreme Court's decision in Wiley v. County of San Diego, a 1998 case, where the court held that when a former criminal defendant sues his or her attorney for legal malpractice resulting in conviction, the former defendant's actual innocence of the underlying criminal charges is a necessary element of the cause of action, and the plaintiff must obtain post-conviction relief. In yesterday's decision, the court essentially extended this rule to defense counsel's representation of the plaintiff in a probation context. Next, in the area of conservatorship. In Conservatorship of Cornelius, the First District held that a temporary conservator's expenses, including reimbursement of attorney's fees, could be recovered under Probate Code Section 2641 and 2642 and paid out of the conservatee's estate, even though the conservatorship was temporary and not permanent. The statutory language provides simply that a, quote, conservator of the person may petition the court for an order fixing and allowing compensation for services, close quote. The court noted that this language does not distinguish between a temporary and permanent conservator, and the court reasoned that so long as services actually were provided in good faith during the period of the temporary conservatorship, the statutory policy would be furthered by permitting reimbursement for expenses out of the conservatee's estate. The issue is not whether the conservatorship was temporary or permanent, but whether there were genuine services provided in good faith to the conservatorship. Finally today, liability by an independent contractor, or rather an independent contractor as plaintiff, trying to sue for damages. In Gravelin v. Satterfield, the First District held that a worker who had been hired by an independent contractor who was injured while installing a satellite dish on the roof of a residence could not sue the homeowner for premises liability. Now, as a general matter, when the employees of an independent contractor are injured in the workplace, they cannot sue the party that hired the contractor to do the work. An exception to this rule exists and imposes direct liability upon a landowner for maintaining premises with a pre-existing hazardous condition that is not apparent to the worker, where the landowner fails to warn of the condition. In the case before the court, the worker tried to climb on top of a small roof extension to get access to a second-story roof. But when he stepped on the roof extension, it collapsed and he was seriously injured. The worker was 6 feet 7 inches tall, weighed 225 pounds, and was carrying 45 pounds of tools. The court held that in the circumstances, the worker had an obligation to inspect the roof to determine for himself whether it would support his weight, and there was in fact no evidence at all that the roof was improperly constructed or contained any hidden defects. It was simply a small roof extension that could not support that worker's weight. The First District affirmed summary judgment for the homeowner. Well, that's it for today's Kelso Report. Have a great day in the law.